If your loved one is currently in jail facing criminal charges, there are some important things that you should keep in mind. Number one, let them know that they need to remain silent and not talk about their case with anyone while they're in jail. Sometimes people are a little too open and they talk about what they're accused of or what they did or didn't do, and that ends up getting reported to a prosecutor, reported to the police, and used against them. So the people inside the jail cell are not their friend. The first opportunity you get to talk to them, you should tell them that they should keep to themselves and not talk about their case in any way, shape, or form while they're in jail. That same advice goes to the phone. Every phone call is recorded, and those recordings go directly to the prosecutor. So they should absolutely not be talking about their case on the phone to you or to anybody else. Those calls are recorded. All of their mail is being opened and screened and copied and given to the prosecutor. So talking about the case or even saying anything that can be taken out of context and used against them can really hurt in the long run. So they should stick to their right to remain silent and not talk about the case openly at all while they're in jail. Now, beyond that, one of the big things that everybody wants to know is bond. How can I bond my loved one out? So let's talk about bond. How and when is bond set? So generally, the arraignment, which is when the person is going to be taken in front of the magistrate judge and have their charge or charges explained to them and have their bond amount set, should happen within 24 to 48 hours of them going into the jail. Every once in a while, if somebody's arrested in a city jail and they're waiting transport to the county jail, that process can be slowed down. But in general, especially if you go directly to the county jail, then bond should be set within 24 to 48 hours. Bond is determined based on a lot of factors. What the person is charged with, their criminal history, if any, if they've ever been on bond or probation before, whether they were successful or they violated the terms and conditions of their bond, the danger to the community, and their ability to pay, among other factors. So that bond will be set by a magistrate judge, but it's not the end of the story. That bond could possibly be reduced. Some courts will automatically have a bond review hearing, whereas if they don't, the lawyer you hire can go ahead and file a motion to reduce bond or reconsider bond and ask the judge in the court to reconsider that bond that the magistrate in the jail initially set. And that's a hearing where family or loved ones can come down. People can talk about how they, have ties to the community, how they've never been in trouble before, et cetera, et cetera. Beyond that, types of bonds. There are three basic types of bond. Cash bond is the full bond amount. If the bond is set at $10,000, then a cash bond is paying the full $10,000 in cash directly to the county, not through a bonding company, not through anybody else, directly through the county. The upside to a cash bond, if you can afford it, is that at the end of the case, as long as the person has reported to court and not violated the conditions of their bond, then you're going to get 100% of that money back that you posted for bond, so the full $10,000 minus a $50 processing fee. Now, of course, the downside of a cash bond is that it's expensive, that not everybody can afford the full bond amount, especially so quickly while their loved one is in jail. So that's where the next type of bond, which is called a surety bond, and that is when you use a bonding company or a bondsman. So generally, that's when the bonding company, bond person, puts up the bond for you, and you pay a lower percentage, usually about 10%, to the bond company. Then you have to follow the rules of the bond company, which is usually checking in and reporting and that sort of thing. The upside of going with a surety bond through a bondsman or a bond company is that you save a lot of money. You're only going to pay 10% or so of that bond. The downside is you're not going to get any of that money back at the end of the case. So there are pros and cons, and obviously if you can afford a cash bond, that may be the best way to go for you. The third type of bond is what's called a personal recognizance or PR bond. That is when you don't put up any money, you just get released based on your promise to return. Those are generally only available for lower level cases and misdemeanors that don't involve violence. The final thing that you should keep in mind if you have a loved one who has been arrested and is currently in jail is to talk to lawyers and hire a lawyer as soon as possible if you can at all. You do not want to delay. There are things happening all throughout the process. It can be slow and it can feel very frustrating, but there are important deadlines that could be passed if you don't hire a lawyer early in the process. So there are things that the lawyer could be doing early in the process, like arguing for an intake rejection, asking a grand jury to dismiss the case, asking for a bond reduction, conducting important investigation in the case, that you don't want to slip through the cracks. The sooner you can hire a lawyer, the better. Hopefully this information is helpful, and you can always reach out to us here at the Law Office of Mark Howard if you have additional questions.